Hello and welcome back to another edition of GNAT-TV's In-Depth series. I'm Andrew McKeever, the news director at GNAT-TV's News Project, and it's a pleasure to have you with us today on Monday, October 17th. Today our topic is Article 22, or Proposition 5, as some people might remember it from before the state primary in August. That's the article that would be an amendment to the state constitution that would allow for or enshrine reproductive liberties in the state constitution. So we're very pleased today to be joined by two folks who are going to be speaking to opposite sides of this article, which has certainly generated a lot of interest, certainly down here in Bennington County. A lot of lawn signs out on the sides of the roads on this subject. And to bring some clarity to all of this discussion, we're very pleased to have with us today Representative Ann Donahue, who represents a district in the state legislature up in Washington County that includes the towns of Northfield and Berlin. She is also a spokeswoman for the Vermonters for Good Government Action, which is a public policy group based in Montpelier and which is opposed to the passage of Article 5. It's also a great pleasure to have with us in our virtual studio, Lucy LaRiche, the Vice President for Public Affairs at Planned Parenthood Northern New England and Planned Parenthood Vermont Action Fund, and a group which is supporting the passage of Article 22. Well, a lot to get to here, Ann and Lucy, and again, thank you very much for making the time for this conversation on this important subject, which clearly has captured the interest of a lot of folks around the state. And Ann, let me start with you, if I may, and have you tell us a little bit about why your group is opposed to the passage of the proposed amendment to the state constitution.
Sure, thanks very much, and thank you for hosting this dialogue. I think there are a lot of people who are under some misimpressions or some, false ideas. First of all, that Roe v. Wade, the overturning of it somehow creates a risk to Vermonters' rights. And also that voting no would suddenly create restrictions on access to reproductive health care, and specifically to abortion rights. Advertisements like, well, what if something's going wrong with your pregnancy? And of course, that's not at all accurate. The Attorney General on the website makes it clear there are no legal restrictions in Vermont, and that wouldn't change. But I think that a lot of people are not aware that our current law does offer unlimited access to abortion. And yet there's really a fundamental consensus, the one area of consensus, if you will, in the United States, and presumably in large part in Vermont as well, that third trimester late term abortion after a baby is viable, if they were born, should not be without any kind of restriction by the state. Yet Article 22 would lock that into the Constitution. I think people aren't necessarily aware that that's current law. And so by saying, well, we're just putting current law into the Constitution, the difference is that we're locking it in so that there wouldn't be the opportunity in the future to say, boy, we've got some problems around this. And we don't want to say that as a value in our Constitution, that there should never be any restriction at all, even for just elective abortions. There are a lot of issues with the language as well. It's the second part of our concern, but we can maybe get back to that because I don't want to take the whole start off here.
All right, well, very good. So Lucy, over to you. Why should Vermonters vote for this bill in your opinion and the opinion of your organization?
So at a time when politicians in half of the states in the country are moving to ban or severely restrict abortion access, Planned Parenthood Northern New England and Planned Parenthood Vermont Action Fund supports Proposal 5, the Reproductive Liberty Amendment, because it will protect the full spectrum of reproductive health care, including abortion and contraception, and will ensure that important personal health care decisions remain between patients and doctors, not politicians. Vermonters have had this freedom for the last 50 years. Passing Proposal 5 will ensure that the rights we have today won't be gone tomorrow.
Well, let's look a little bit at the exact language of the amendment. It's fairly short. It states that an individual's right to personal reproductive autonomy is central to the liberty and dignity to determine one's own life course and shall not be denied or infringed unless justified by a compelling state interest achieved by the least restrictive means. I was kind of surprised that the word abortion wasn't specifically referenced in it. Lucy, let me go back to you. Do you feel that this the language in the bill is kind of clear enough for people?
Yeah, I really do. I think it's one beautiful, elegant sentence. What I think a lot of people don't realize, and that this is just how laws work and the courts work, is that terms and language is defined already in a lot of places in court law, in court canon. So the words personal reproductive autonomy have been really well defined over decades of Supreme Court law to mean very specifically and very narrowly the right to get pregnant, carry a pregnancy to term, the right to choose or refuse contraception, the right to choose or refuse sterilization, and the right to access abortion. These rights, what this amendment would do is would prohibit government interference with a patient accessing any of those healthcare services if they wanted those things. So no, I don't think the language is vague. I think it's actually very clear and has been well defined. Additionally, if there were ever a question in court, then the judge and the courts would also have the opportunity to look at the legislative record as well as contemporary accounts from the press to see specifically what the amendment language is intended to include and what the legislative intent was, as well as the decades of Supreme Court cases that have defined the words personal reproductive autonomy.
I want to just briefly refer back to the start of our conversation and the reference, as Lucy just said, about the intent to prohibit interference. And Lucy said, politicians in half the country are trying to restrict rights. We're in Vermont. We're looking at law for Vermont, not for the country. I think it's important to realize that our own Supreme Court spoke on this 50 years ago. That's why we have 50 years of history, 1972. That created the fact that we have unlimited rights currently. And even to reduce them at all, they couldn't be eliminated, but to even do anything would pretty much require a radical change in the electorate in Vermont. It's not going that direction in any way, and it would be a pretty radical shift. Even the most conservative legislatures in the past 50 years have never passed any laws with restrictions. So I don't think that there is a valid risk to Vermonters, and I don't think that pointing to what's happening in other states is really relevant to our law or our our electorate. It's not about politician decisions. It's about who's elected by Vermonters to represent their interests in the legislature. But in terms of the language, there are new elements here that are not part of any prior jurisdiction, in the sense that we're talking about men and women. I'm delighted to see equal rights, but there isn't a precedent for personal reproductive autonomy that isn't focused on women, particularly in terms of abortion. I would disagree that it's well defined. I think that even in legislative history, if you look at some or listen to some of the hearings, there was a specific decision to not include The same words that are in our statute of a couple of years ago, which specify just what Lucy said, right, decision to have a child or not, decision about contraception and abortion. But there was a specific discussion and decision to not use that language because of wanting to leave it open for future developments, changes in science, in whatever may happen in the future. And that was explicitly part of the intent. And I think that's one of the concerns. Those kind of major public policy decisions belong in a public forum, public process in the legislature, reflecting what constituents want, not in the hand of 5 judges to decide what it should or shouldn't be as public policy for Vermont. We've seen the effect of what just a group of judges can have on major policy, and I don't think it belongs in the courts for questions that come up about the scope of the language.
Well, let me ask you a follow-up question to that, Representative Donahue. I guess one of the key pieces to the concerns of folks who are opposed to the passage of Article 22 seems to be that it would allow for late-term abortions. That seems to be on every lawn sign I've seen down here in Bennington County anyway. Is that, why shouldn't that be possible for a woman who might decide at that point that bringing a child, a pregnancy to term, isn't what's going to be best for her or for the child?
I think what's important to understand is the concern is with elective abortion, not issues of health or safety, not those kind of concerns. Saying that it should be regulated, that there should be oversight, is not saying that they should all be banned. California has that law now. That's incorporated into their constitutional proposal, which is very similar to Vermont's. But I think it would really reflect what has always been under Roe v. Wade itself, where the Supreme Court really stressed the fact that at a certain point in time, the woman's privacy rights are no longer sole, that the potential human life becomes significantly involved. That's the court's words. And the court said that in respect to what that point should be, it should be at viability, which is actually now generally considered about 22 weeks. That's what UVM, that's what California looks at. And I want to just give you the quote from the Supreme Court. This is so because the fetus then presumably has the capability of meaningful life outside the mother's womb. So it becomes an interest for the state to balance that interest, not to say that it always is superior, because there are a lot of different circumstances. But right now, UVM, which is the only one that does a termination of a viable infant, they have policies that review whether they believe it's ethical or not. But if they don't think it's ethical, they simply refer the woman out of state. We don't know for sure where those policies go into the future. There's no ability of the state to step in if other providers come into the state who are not following that kind of ethical guidance. So I think there's a really significant interest. These are cases where the physician has to actually inject what they call a feticidal drug into the baby to ensure that it isn't born alive, because otherwise, when they induce labor, the baby would be born alive. And so they have to kill the baby beforehand in order to not be, and this is in the words of the physician from UVM, so that you don't get the situation, quote, where a fetus may be born partially alive and then exterminated. That's what we're trying to avoid if there isn't a valid reason. And there are a lot of potentially valid reasons, but there's validity to the state having an interest in the life of another person that's involved at that point. As the Supreme Court said, when the woman's interest is no longer sole?
First of all, the fact that there are more ways to regulate something than through the government, and the healthcare system and healthcare professionals have systems in place, as Representative Donahue mentioned. The UVM Medical Center is the only entity in Vermont that performs abortions at 21 weeks and six days. That's as late as they go at UVM Medical Center. And if an abortion is to happen at that point in time, it is not elective. There are no elective abortions that happen beyond that point. And there are only 1% nationally of abortions that happen in the later in pregnancy. And I want to just back up for a second and make sure that your viewers understand this term, this language of late-term abortion is a political term. This is a social term. This is used by abortion opponents, people who want to restrict access to reproductive rights, it's language that's used to try to shame patients. In reality, the very, very few abortions that happen later in pregnancy are not elective, and they're done for reasons of fetal anomaly, if the pregnant person's life is in danger or the fetus's life is in danger, or there are intense complications that arise. I think it's also important for people to understand that there are certain diagnoses that can't happen until about 18 weeks gestation, and those tests are, those tests can find out things like whether or not a fetus will be viable outside the womb. And I think if opponents of abortion really cared about limiting abortions that happen later in pregnancy, then they would have to agree that government regulation of abortion later in pregnancy is dangerous. And it is that very thing that causes the gestational age of patients to push out and out, because it's the regulations that create barriers to access to care. If a person finds out that they need to access abortion later in their pregnancy, or even in the beginning of the second trimester, if they live in a state where restrictions exist, such as viability bans or gestational limit bans, and they have to find care. First of all, it's more expensive. It's a lot more expensive to have an abortion later in pregnancy. 92.2% of abortions in Vermont happen within the first 12 weeks. The Department of Health has the data. Every abortion in Vermont is reported. So if you have a complication with your pregnancy, or even if you don't, but you find out late, you find out it's 18 weeks or at the end of the first trimester, but you live in a state that has restrictions, and you can't find a healthcare center that performs abortions, or you need to go out of state, or there are travel restrictions or other restrictions to care that the government imposes on somebody's healthcare, then that pushes the gestational age of that pregnancy out further and further and further. So in fact, by the time they do access the care, the gestational age is later, and it's dangerous. We know that states that regulate abortion through the government have much higher maternal mortality rates. And this is why politicians are not healthcare providers. Healthcare providers are qualified to take care of patients. If they're worried about politicians and about losing facing medical malpractice or facing jail time because they performed an ectopic pregnancy, as that was the case I heard in a state where abortion is banned. Ectopic pregnancy, in case folks, just to be clear, an ectopic pregnancy is when a fertilized egg embeds in a fallopian tube or outside of the uterus, and it can be fatal to the person who is pregnant if not addressed right away. So when you're delaying care, you are pushing gestational age out, and you are causing harm. And in the end, politicians are not qualified to be making these cookie cutter decisions for a condition that is incredibly complex. Pregnancy is complicated. It's a complex medical condition, and politicians are not equipped to do this. Politicians in other states where abortion has restrictions, they're trying to put one size fits all kind of regulations on healthcare that's very complicated and requires medical practice and medical expertise to address. So I think there's actually no good reason to restrict abortion later in pregnancy, especially because it is so incredibly dangerous to do so, and because it is so incredibly rare, and because it doesn't happen in Vermont. And this idea that passing this amendment is going to all of a sudden create all of these elective third trimester abortions is absolutely absurd. It hasn't happened for the last 50 years, and we have had no restrictions in Vermont for the last 50 years. This has not happened for the last 50 years. And there have also been states that have gestational limits and viability limits where if patients thought that Vermont was a haven, that they could come here. That hasn't happened. So this is a dog whistle. This is an alarmist. This is a scare tactic, and it's just not real.
Nobody's suggesting there'd be a big increase in the desire or that there is a huge desire out there. The concept that it's not happening, well, I think, as Lucy just pointed out, laws are changing in other states. That's exactly the problem and the issue. All of the, real horror stories she was talking about are things taking place because other states are putting restrictions in place that Vermont is not in any way suggesting or proposing. Restrictions that are barred by Vermont law, which has no restrictions. So, I think, again, we're not looking at the Vermont issues when we look at concerns about other states. And I think what's important to recognize is that even when we're talking about things that like, late-term abortion, which is simply a colloquial term, if Lucy would prefer it, we could say, as California law says, viable abortion after viability. So, that's probably a more accurate term, but a little less clear maybe, but less colloquial. But the fact is that currently UVM, it's not that they don't happen. UVM has said they send them out of state if it's an elective abortion, if it doesn't meet their ethical standards. And we also know that there are other providers in the country who do give elective late-term abortions. Not a lot of them, it's not a huge number, but they happen. They advertise to women in New York. In Vermont, they advertise for women who are seeking that because Vermont doesn't currently offer it. But at any time that could change in terms of Vermont because there are no restrictions in Vermont. And as restrictions increase in other states, that's where it makes it more likely that providers themselves will come to open practices in Vermont. And in fact, with this constitutional amendment, UVM's own policy might be found to be unconstitutional, and certainly any regulation which is already barred, state action is barred completely under our current statute. So the ability to say, for instance, well, you're violating professional ethics, we're going to take away your license. That's really clear from the 1972 Supreme Court case that you cannot regulate abortion through regulating doctors' licenses when it's a legal procedure. And this is legal in Vermont, but it would be locked in so that we never could change our approach when it comes to post-viability abortions, which is the sole focus here of the concerns. Our Supreme Court ruling would not permit the kinds of things that are happening in other states, nor would our constituents permit it to happen. But that area is where there is huge consensus across the country that we're just, people prefer to see the regulation in place when we're talking about elective post-viability abortions. And we would not be able to do that in the future if this constitutional amendment was adopted.
One thing I want to say is about the threat. I mean, currently, Representative Donahue is correct. There is a law in Vermont that protects abortion rights. At the same time, since I used to serve in the legislature, and since 2005, every single year, without fail, there have been bills that have been introduced in the Vermont legislature that would severely restrict abortion or ban it. Those bills haven't been taken up or passed by the most part. But I guess the point here is that our election cycle is only 2 years for elected officials in Vermont. And we have seen that what can happen at the national level. We've seen examples of how quickly things can turn around. I do not think that if people think that reproductive rights are important, it's important to enshrine them in our Constitution, because in any given moment in time, we're only 2 years away from the next legislature who may not be as friendly as the current one to abortion rights. I will say that.
I have to say, Lucy keeps saying it's been 50 years. We've had a lot of different legislatures. It may be 2 years, but we've gone 50 years without any successful bill. Legislators introduce bills every year that go nowhere, the vast majority of them. So there are a lot of wild things that get introduced. It doesn't mean that there's a remote threat. It just means that there are some people.
Well, I'm just really glad that you have that confidence. I do not. And I think a lot of Vermonters do not either, because they care about the next generation and the next generation after that. And they care about peace of mind for Vermonters' ability to have these rights for their children and their grandchildren and their great-grandchildren for generations to come.
Why was it pressed why was there a refusal by the legislature to include an exemption for post-viability abortions, which could have been done from the start, which was proposed and discussed? There was a refusal. And
for very good reason, because politicians are not physicians. Politicians are politicians. And pregnancy is a very complex condition. And sometimes viability is not clear cut. Sometimes one person can look at a pregnancy and declare that they think it might be viable, and another will think that is absolutely not viable. And it's not just a number.
California puts it in the doctor's judgment. That's right. It's weight. California puts it in the doctor's judgment as to whether there's viability.
We're going to leave it in the doctor's judgment, then why do we need it in? Why do we need
the unethical
to give the politicians the ability?
The unethical ones that UVM sends out of state and happen. That's the issue. California says they're not legal.
I think you were trying to create an opposition to a problem that does not exist. And I think you might feel the same about this amendment, but I think that's probably the heart of the matter here.
But unfortunately, we're going to have to leave it there for now. On November 8th or before, if you're voting early, you'll have your chance to weigh in on this question on Article 22. I want to thank again Representative Ann Donahue and Lucy LaRiche of Planned Parenthood Northern New England for being with us today. Thank you both very much for making the time. Thanks for being with us today.